Welcome to today's webinar, brought to you by the Current Consulting Group and sponsored by DrugPak. Today's presentation is titled Marijuana Laws Influencing the Workplace, How Employers Can Stay Ahead. Today's webinar qualifies for one continuing education credit from SHRM, HRCI, and CCDAP for those who attend in its entirety. You will receive information following today's webinar on how to apply for that credit. Today, we'll be sharing with you a short video from our sponsor, DrugPak. The audio for the video is available through your computer speakers only. So if you have dialed in for today's presentation, please be aware that you will not hear the audio. And with that, we're excited to hear from today's webinar sponsor. So let's go ahead and turn it over to David Gonsalves, General Manager at DrugPak.
Hi, I'm David Gonsalves, General Manager and Partner at DrugPak. We are excited to be sponsoring today's presentation of Marijuana Laws Influencing the Workplace. Before I turn things over to Bill Current of the Current Consulting Group, I want to share a short video I put together and say a few things about DrugPak I hope you find interesting. DrugPak has been serving the drug testing industry for over 30 years. My team is happy to have this kind of track record and legacy. DrugPak began when software for drug testing was very new. In fact, we were the only comprehensive drug testing management software available. Back in those days, DrugPak was an off-the-shelf product built to meet the needs of drug testing providers then and into the foreseeable future. As Bill will talk about today, drug abuse trends change from year to year, and drug testing methods have evolved in many significant ways. For that reason, DrugPak has changed as well, always with an eye toward meeting the current and future needs of program administrators. The DrugPak of today is a web-based, comprehensive, flexible, automated, and fully scalable drug testing management system. With AI features like machine learning-based form reading, DrugPak enables TPAs, MROs, and employers to do their work in a streamlined, efficient, and cost-effective manner. Now, with support for physical exams and with background check support coming soon, DrugPak is pleased to announce that we support integrated test ordering interfaces with all the major labs. In other words, the 2024 version of DrugPak is better than ever, with solutions for everyone. Now for a brief message. Thank you for your time today. I am so pleased that DrugPak support can make valuable informational webinars like this possible. Now, finally, it's time to hear from Bill Current on marijuana laws influencing the workplace, how employers can stay ahead.
Well, thank you very much, David. And as I'm sharing my screen here, let me just say that one of the truly interesting things that I have found with DrugPak is that we conduct a survey of the drug testing industry every year. We've done it for 26 years in a row now. And as part of that survey, we ask a series of brand name recognition questions. And so what are the top 3 brands in order that come to your mind when you think of lab-based urine testing, lab-based oral fluid testing, MRO services, etc. And for the last 3 years, DrugPak has ranked #1 as the #1 recognized brand in drug testing management software and cloud services. And what I find fascinating about that is that, as David mentioned, they've been in business for 35 years. I mean, to be relevant all of these years later and to be recognized in a survey of drug testing professionals, of your peers, as the most recognized brand in drug testing management and software and cloud services is quite a tribute to DrugPak and the strength of their brand. So congratulations. And it's great today for me to be participating in this survey. I have been in the drug testing industry for 36 years, so 1 year longer than DrugPak's been around. Probably pretty close to the same time we got started, actually. But through the Current Consulting Group, we work with all the major companies in the industry. And so it's our privilege to be associated with those laboratories that David referred to, and to DrugPak itself and many other top brands in the drug testing industry in providing the compliance services and the marketing support services that we specialize here at the Current Consulting Group. Now, here's today's agenda. And I'll put this up on the screen, but I just want to say, any questions you have, put them in the Q&A section or the question section there. I'm happy to address any issues. I'm going to be talking a little bit about drug testing methods as they relate to marijuana. I'm going to be talking about state marijuana laws. We just had a general election. I live in Florida. The Florida initiative to legalize recreational marijuana, to change our state constitution to allow for the legalization of recreational use of marijuana failed. Excuse me. As did other initiatives throughout the country. And so it's just a very intense time when it comes to marijuana. Some of you may know that under the Biden administration, the DEA has moved to reclassify marijuana from a Schedule I controlled substance to a Schedule III controlled substance, which would de facto make marijuana legal for banks to handle financial transactions in the cannabis industry, which technically under federal law is not allowed. And others, it would make it legal for doctors to prescribe marijuana as opposed to simply recommending it. So a lot of things going on right now with marijuana, the whole marijuana legalization issue. So any questions you have along those lines, let me know. I'd be happy to address them. And as Greta said, if there are any that we don't get to today, then we'll respond in an email and provide an answer for you. So just as sort of a generalization and start to our presentation today, positive drug test results are up, they're increasing. You see that in the Quest Diagnostics Drug Testing Index report that comes out every year, came out back in May, was released at the NDASA conference, which is where we released the results of our industry survey as well. We saw an increase in positive drug test results, excuse me, and we're also seeing more states making drug testing, especially testing for marijuana, more challenging. You see New York, California, Washington there in that second bullet. I'll talk to more specifically about that in today's presentation. And you're also seeing, and this is very evident in the surveys that we conduct every year, the drug testing industry survey, which is in its 26th year, and then the employer survey, which is in its 8th year. We're seeing an increase in interest and in use of alternative drug testing methods, especially rapid result testing. You know, the single-use disposable devices, either with urine or with oral fluid. I don't know if many of you have heard, but there's also now a rapid hair test that's available from Wanfo. So rapid testing is sort of like climbing the ladder quickly in terms of interest and usage. But we're seeing as in terms of alternative testing, interest in lab-based and rapid oral fluid testing. Excuse me. So some statistics I'm going to go over in these next couple of slides. Look at the first bullet. 40% of people who work from home full-time say that they've gotten high before or during work hours. In a 2024 survey of marijuana users from Hound Labs, 48% admitted that they use marijuana at work, including during breaks and lunch breaks and things of that nature. But also 31% admit that they use marijuana on their way to work. So they're using marijuana while they're driving to work, and they're arriving to work with marijuana in their system, and in many cases probably impaired by marijuana. Now, the survey found, that Hound Labs survey found that 60% of the participants work for companies that don't do any drug testing. So they feel emboldened to use marijuana on the way to work, to use marijuana on their lunch break, et cetera, because nobody's testing them for marijuana. And almost all of them, 92%, work in a state with either recreational or medical cannabis legalization. In other words, it's legal under certain, with limited, applicability in these states. It's not legal under all circumstances, but many of these people work for companies that don't conduct drug testing. So we're seeing a pretty dramatic increase in positive drug test results for marijuana. Over the 5-year period, this goes back to the Quest Drug Testing Index. Over a 5-year period between 2017 and 2021, positivity for marijuana increased by 50%, from 2.6% in 2017 to 3.9% in 2021. You may think, well, that's a minor increase, 2.6 to 3.9, but that represents hundreds of thousands of people testing positive in that 50% increase category. Second bullet, marijuana positivity particularly surged in states with legal recreational marijuana, 118% between 2012 and 2020. And then overall positivity rates in the combined U.S. workforce, looking at the millions of tests that Quest does every year, increased dramatically. But go down to that last phrase in there, up 31.4% from the all-time low of 3.5% 10 years ago, between 2010 and 2012. So we're seeing a dramatic increase in marijuana use that coincides directly with the legalization of marijuana in so many states now. And testing for marijuana is very important if your concern is maintaining the safety and the well-being of your workforce. So as part of the Current Consulting Group's 2024 drug testing industry survey, not the employer survey, but the industry survey, we asked what percentage of your clients have dropped marijuana from their drug test panel in the last 12 months. 78% said at least some, right? So there was some, many, there were different categories at the mark, but if you combine them all, 78% said at least some have stopped testing for marijuana. Doesn't mean 78% of their clients have, but 78% of respondents said they've had at least some of their clients stop testing for marijuana. 17% said more than 10% of their clients have dropped testing for marijuana. And then at that last bullet, just over 43% don't believe these companies will ever reinstate testing for marijuana, even though we have seen that happen, especially over the last 3 years. As the rate of testing for marijuana was dropping, we're starting now to see a slight increase in the percentage of companies that are reinstating testing for marijuana. Some very large companies, big brand names, have come out publicly to say that they're not testing for marijuana anymore. But if you look carefully at many of those companies' policies, they're still testing for marijuana after accidents and reasonable suspicion scenarios. Even those companies are still testing for marijuana under certain circumstances. Now, the decision to stop testing for marijuana, in my opinion, is misguided when you look at the reasons why companies say they stop testing for marijuana. So we asked in our survey, why have clients dropped marijuana from their drug test panel? 62% said that testing for marijuana makes it harder to hire people. 44% said they're trying to avoid the risk of a legal challenge from someone who's mad or upset that they tested positive for marijuana and didn't get hired or got fired, etc. And 34% said it was because it's not legal to test for marijuana in the states where they do business. Well, the truth of the matter is it's legal in all 50 states. I'm gonna show you some examples here, okay? Because I know there are people who are gonna say, well, what about New York, right? There are conditions, there are exceptions, okay? But the good news is that testing for marijuana can be conducted in all 50 states, even in New York under very, very limited circumstances in New York. New York is the most restrictive state when it comes to testing for marijuana, but there are some exceptions. Go into those Department of Labor regulations that essentially say you can't test for marijuana, and you'll find the exceptions listed in their regulations. You can test after certain types of accidents or under certain circumstances, and there are always exceptions. If you look at any state that appears to have some kind of restrictive language when it comes to testing for marijuana, there are always exceptions for safety sensitive occupations, law enforcement, firefighters, sometimes in the health industry and hospitals and treatment centers, etc., childcare facilities, but also anytime, like in the Washington law, you'll find language, and I don't have it in front of me, so I'm paraphrasing, but it's basically any type of occupation where the individual functioning in the job impaired by marijuana could harm or kill someone, that job is exempted from their restrictions in that state. So the things you want to look for in a legal marijuana law, and not all marijuana legalization laws have this in them at all. Some of them don't have any reference to the workplace, but the ones that do, you want to look for any sort of language that prohibits employers from discriminating against legal marijuana users. And typically it'll have some kind of language in there that refers to using marijuana on their own time away from the workplace. And often it's related to medical marijuana specifically. And then you also want to look for language that talks about it, that, you know, the restrictions on the marijuana users. Individuals may not use marijuana or be under its influence while at work. Now, you may be asking about California and Washington. Those are two states that in January of this year had new laws go into effect that restrict testing for marijuana with a testing method that is only capable of detecting the non-psychoactive metabolite of cannabis. Okay, so let me give you an example. Here's California. So I'm going to read straight from the law. There's a little bit, you see some ellipses in there because I'm going to paraphrase in a few places, or not paraphrase, but skip around a little bit. So in California, AB 2188, that went into effect January 1st, 2024. It is unlawful for an employer to discriminate against a person in hiring, termination, or any term or condition of employment, or otherwise penalizing a person if the discrimination is based upon, among other things, an employer-required drug screening test that has found the person to have non-psychoactive cannabis metabolites in their hair, blood, urine, or other bodily fluids. That's what the law says in California. Well, when you look at that hair, blood, urine, or other bodily fluids, you're thinking like I was thinking originally when I first read it. That's every drug testing method that's out there. However, the law also includes this language, and I'm going to read these two bullets to you. As science has improved, employers now have access to multiple types of tests that do not rely on the presence of non-psychoactive cannabis metabolites. These alternative tests include tests that identify the presence of THC in an individual's bodily fluids. Okay, so let's pause there for a second. So with a testing method like urine drug testing, you're detecting the metabolite of marijuana, of cannabis. Okay, you're not detecting the drug itself, you're detecting a metabolite. It takes the body 6, 7, 8 hours for the metabolite of THC to become detectable in a urine sample. With oral fluid, however, oral fluid drug tests, whether lab-based or rapid result, you're detecting the drug itself. You're detecting parent THC, delta-9 tetrahydrocannabinol, not a metabolite, but the drug itself. So now let's look at the second bullet. The law does not prohibit an employer from discriminating in hiring or any term or condition of employment or otherwise penalize a person based on scientifically valid pre-employment drug screening conducted through methods that do not screen for non-psychoactive cannabis metabolites, i.e. oral fluid drug testing. That is so interesting because in California, these restrictions on using a testing method to test for marijuana that only reveals the presence of the quote unquote non-psychoactive metabolite of cannabis, it applies to both pre-employment and post-hiring drug testing, with a big giant exception for the construction industry. So they obviously had some say in the language to this new law in California, AB 2188. Okay. In Washington, the restriction is very, very similar, except it only applies to pre-employment testing. And even for pre-employment testing, there's a very long list of exceptions. In California, the one industry that's exempt from the restrictions is the construction industry. In Washington, it not only applies to pre-employment testing, but there's a long list of exceptions to the law, including occupations that an individual could, while under the influence of drugs or while impaired by drugs, cause harm or death to another person. So Washington, a little bit looser than California, right? Because you can still use urine and hair testing for employee drug testing. Very interesting. So when you're looking at these marijuana laws, you want to look for any language that talks about discrimination and what the limits of that discrimination are, so that employers can take advantage of the things they can do. In California and Washington, for example, You can't test for marijuana with urine testing under most circumstances on pre-employment and in California for post-hire as well. But you can use oral fluid testing, right? So my advice is test for marijuana, but comply with the laws that apply to you. Let your employees know what you're doing and that any violation of the company policy related to marijuana, being at work under the influence, etc., testing positive, again, within the confines of the laws that apply to you, may result in adverse employment action, okay? Especially, look at that third bullet, especially testing workers in certain safety-sensitive occupations, typically permitted without restriction. If you're in a safety-sensitive industry, look at those laws, those marijuana laws very carefully, because it's very possible that your industry or the kind of work that your workers do is exempt from the restrictions that apply in that state. And then very importantly, the fourth bullet, a legally compliant drug test is still the most effective way to prove that somebody has drugs in their system while at work, which is typically a violation of your company policy. So don't give up on drug testing and don't give up on testing for marijuana. Let's go through 3 different reasons why it still makes sense to test for marijuana, okay? A company that's thriving versus a company that is simply surviving, okay? Now, some of this is going to be a little bit repetitive, but you know that the legalization of marijuana has resulted in more people using marijuana and more employees testing positive. We have all the statistics to back that up, right? And more people using marijuana and being hired because a company doesn't test for marijuana results in some very predictable outcomes. More workplace accidents, workers' comp claims, the usage of healthcare benefits, turnover, absenteeism, and reduced productivity. Now, it's very interesting. A client brought this up with me yesterday on the phone, talking basically about workers' comp claims, and that in many states, you have to have a positive drug test result in order to move to deny or challenge a workers' comp claim based on an individual being impaired or under the influence or having drugs in their system in violation of a company policy. In order to have the right to move to deny that claim or to challenge that claim, you have to have a positive drug test result. You'll look at your workers' comp laws in the states where you do business. You'll find that this is very, very common, that if you have a positive drug test result, it may be by your state considered de facto proof that the individual was impaired at the time. I'm not saying that a drug test proves impairment, but there are certain workers' comp regulations that are written in such a way that a positive drug test result works in favor of the employer in terms of being able to challenge and possibly even deny a workers' comp claim. If you're not testing for marijuana, you have nowhere to go when it comes to trying to challenge a workers' comp claim based on the accusation that somebody is using drugs or was impaired by drugs. So look at that first bullet. All of that combined, the negative outcomes, puts employers in a constant state of playing defense when it comes to marijuana. You're always trying to defend yourself by trying to justify your program. Whereas if you base your program on the state laws that apply to you, then you're in a very strong position, right? Because you're complying with the laws that apply to your company. In all 50 states, every employer still has the right to prohibit individuals from using marijuana on the job, bringing marijuana into the workplace, and being at work impaired or under the influence of marijuana. These rights are never going away. There's no state that's going to pass a law that requires you as an employer to allow your workers to bring marijuana to work, to use marijuana at work, and to be impaired by marijuana while at work. So that needs to be written into your drug testing policy. And I'll talk about your policy in a few slides from now, okay? So a marijuana-free workplace is just a better place to work. Fewer accidents, higher productivity, less turnover, better employee morale. But a marijuana-free workplace gives employers a chance to truly grow their business without having to face the prospect of legal challenges to your program, which gets us to, in fact, let me just skip ahead here to this part right here. Be clear in your drug-free workplace policy that employees who use marijuana at work, who are impaired by marijuana on the job, or who bring marijuana into the workplace will face adverse employment action, possibly including termination. But again, your policy is going to be based on the state laws that apply to you. You're not going to do something in terms of adverse employment action that goes contrary to any individual state law. One of the questions we get asked here at the Current Consulting Group all the time, because we write hundreds of drug testing policies every year. one of the questions we get asked is, I'm in multiple states, which law should I base my company policy on? So let's say you're a company in 5 states or 50 states. The answer to the question is every state law applies to you. So if you're in 5 states, you need a drug testing policy with addendums to that policy for any differences in the various states that you have business operations in that may vary from your base policy, from your core policy. So the answer to the question is all laws apply to you wherever you do business. But let's say you're in California with its very restrictive laws, but you're also in Texas with a much more employer-friendly, employer-supportive drug testing environment. You don't want to base your Texas policy on the restrictions that apply in California. So you're going to develop a policy based on Texas, but then you're going to put addendums in the policy for California so that in California, you're complying with those restrictions, but you're not extending those restrictions to other states where it's much more employer and drug testing friendly, okay? Again, you're gonna prohibit people from using marijuana at work, being impaired by marijuana and bringing marijuana into the workplace. You're gonna put that in the policy so it's very clear to everyone what the possible consequences will be for that. Now, one of the things we hear a lot about is that we can't find people to hire. So you end up really sort of hiring just anybody to try to fill spots because you're not testing for marijuana because you're afraid you can't find people to hire. A company, as you know, is only as good as its workforce. It's only as good as your employees. And you want a drug-free workplace, you want a safe workplace, and you want workers who are safer and more productive because they're not drug users or they're not bringing their drug use behavior into the workplace. So if you look at the last bullet, dropping pre-employment drug testing for marijuana, for instance, will not necessarily result in more people applying for work within your company. This is interesting. I think it's on this next slide here. This was a survey from years ago from the federal government where they surveyed people who admitted to being regular drug users who were employed full-time. 40% of that group, the regular drug users who were employed full-time, 40% said they were less likely to work for a company that conducted random drug testing, and 30% said they were less likely to work for a company that conducted pre-employment drug testing, whether for marijuana or any other drugs. That's good news if you're an employer because it tells you right off the bat, many drug users won't even apply for a job with your company. They don't want to work for your company because you conduct drug testing. So it's a win-win for you as the employer. You're really going to attract mostly drug-free workers. There are going to be people who test positive in a pre-employment test, and then based on the state laws that apply to you, maybe you don't hire that individual, but you're going to be attracting the best possible, best quality workers who, if hired, are going to probably turn out to be very productive workers. Okay. Now, this gets a little bit detailed here, but the federal government reports that almost 15%, almost 1 out of 6, 14.3% of full-time workers are current drug users. Every year, the federal government comes out with a report called the National Survey of Drug Use and Health, where they track drug use based on tens of thousands of surveys that they send out, that they conduct, I should say, usually by phone or by email. And they identify individuals who admit to being regular drug users, right? Now, of course, some people aren't going to be honest about that in a survey with the federal government. We know that. In fact, the federal government did a study on their survey and found that the results are probably about 30% lower than they really are because people are reluctant to tell the truth. But 14%, about 14% of full-time workers are admitted drug users. Conversely, that means about 85% of your workers, your full-time workers out there in the US workforce, are not current drug users. They're more likely to come into the workforce and not cause an accident, not, have increased absenteeism and not show up for work because they're hungover or high from the night before, and all of the other bullets that you see on the page there. The good news is that most people are not drug users. Most people are not regular current drug users who are going to come to work under the influence or bring drugs with them into the workplace. But you increase your chances of hiring from that 85% group by conducting pre-employment drug testing. So for those who question the value of pre-employment drug testing, I would go back to this slide here. 30% of drug users aren't even going to apply for a job with your company you're already ahead of the game because you're really looking at a much better qualified group of job applicants and more likely to hire the kind of people that you want to bring into your corporation or your company. But really, this is the one that gets me the most: legal defensibility versus legally bankrupt. So the legalization of marijuana in this state and that state has not changed the effects of working under the influence. You know, in other words, just because it's legal, it doesn't mean that somebody who's driving a delivery van for your company is less likely to be impaired after smoking a couple of joints on his lunch break than somebody who doesn't, right? It hasn't changed anything in terms of the effects of drug use on the user. And also, it hasn't changed other doctrines of law that will apply to your company. Two of them that I want to bring up here are negligent hiring and respondeat superior laws. And I really should refer to them as doctrines of law. Generally speaking, these doctrines of law hold employers legally liable for the actions, the behaviors of their employees while functioning within the scope of employment. That particularly applies to respondeat superior, meaning that that delivery van driver high on marijuana who runs a red light and hits another car and causes harm and property damage, etc., your company will be held legally responsible and liable for that worker's actions, right? The injured party have hopefully no worse than just an injury, right? It could be worse than that, but hopefully it's going to be limited to that. But they're going to come after the deep pockets. And so they're going to sue the employer who should have known, who should have made a good faith effort to prevent having drug users driving delivery vans on behalf of the company, right? So negligent hiring and respondeat superior laws have not gone away just because states have legalized marijuana. Here's one example. This involves somebody who was an alcoholic. This was in Kentucky. A jury found an employer liable under the doctrine of respondeat superior, as well as negligence in hiring and training, and was awarded to the plaintiff $5 million in compensatory and punitive damages. My company could not survive that. Many small companies couldn't. Now, the employer was unaware that the individual who caused this accident and injured a customer was an alcoholic, actually living in a rehabilitation center at the time that she was hired. And she caused the accident, injured a customer, and the company was held legally liable for that individual's behavior while functioning within the scope of employment. And they were awarded, the plaintiff was awarded $5 million in this case. That's just one example, but there are others. The point is that drug testing gives you the opportunity perhaps to avoid hiring this person, or maybe identifying a worker who needs help so you can take them out of a safety sensitive position and put them somewhere else while they're getting their life in order. But if you're not doing the drug testing, or if you're not screening individuals, including applicants for marijuana, the #1 illicit drug of abuse, you're putting yourself in a position where you're more likely to hire that individual, and that individual is, according to all the reports and all the statistics, more likely to cause an accident and then put your company in a position where you're held legally responsible for whatever they've done wrong. Okay, so as we go into this final section, what can you do when, oh, well, there's two sections. This is a short one. What can you do when someone tests positive? Okay, look at the state laws that apply to you. Don't look at this list that I put up with all these bullets and say, oh, I've got all these options everywhere I do business. No, you must look at the laws that apply to your company. And every state you're in has a law, and you need to comply with all of those state laws individually for the workers in those states. But the options that may be available to you are suspension, termination, giving somebody a second chance, which oftentimes is a good move for somebody that you've invested a lot of time and money into hiring and training. You might want to get that individual with a substance abuse professional, a SAP, so that they can go through some type of return to duty process where they may be subject to additional testing, treatment, counseling, etc. Sometimes a second chance agreement is the best route to go, right? And you know, that's all sort of, all the last three bullets are sort of, can be part of that process. And if you're required under DOT to conduct drug testing, then there are very specific requirements with return to duty tests and follow-up testing that are going to apply under the direction of a substance abuse professional, okay? Now, that bottom part, I can't stress enough, of those who test positive for any drug test, as long as they comply, as long as you as the employer comply with the applicable state laws and federal regulations, so important. Okay, now addressing marijuana in your policy. Again, be familiar with the laws that apply to you. The best defense against these legal marijuana laws is to comply with them. You're not going to beat them, so comply with them. But understand what your rights are and update your policy to reflect those rights. We track state legislation that can affect workplace drug testing. We do it every year. This year, there were almost 600 bills introduced at the state level that, if enacted, could or would have had a direct impact. The good news is most of them weren't passed or enacted this year, but some of them were. If you're in one of those states that's made material changes to your marijuana policy or to your state's drug testing policy or law, you need to make sure that you update your policy. For example, earlier this year, the state of Minnesota updated its drug testing law to specifically allow for employers to use rapid result oral fluid drug testing, despite the fact that the state has a laboratory licensing law that on the surface would make it appear that all tests have to go through a laboratory or be analyzed through a reader system used by a laboratory. But now, by law in the state of Minnesota, this happened during 2024, employers can use rapid result oral fluid testing. If that's a change that applies to you, you want to make sure you update your policy so it reflects that. It's important to know that no two state laws are identical. There's not some model policy that they all followed for how they will allow or restrict drug testing. So understand the laws that apply to you, whether it's marijuana laws or drug testing laws. They vary from state to state. Very important to understand that, okay? Now, I'm going to say use a drug testing method that's been endorsed by the federal government. There are others that I think are just as good, but let me put it this way. There are only two methods that offer the highest level of legal defensibility if you're going to use the federal regulations, Part 40, the SAMHSA guidelines, as the blueprint for your program. That's lab-based urine and lab-based oral fluid testing, which is still in the process of having labs certified, but we're within probably a short handful of months before it becomes fully enacted, those lab-based oral fluid testing guidelines, which will make it possible for DOT-covered workers or employers to use lab-based oral fluid testing. Now, there have been proposed regulations for hair testing. It's still sort of sitting on the starting block, so I wouldn't put it in the same category with lab-based urine and lab-based oral fluid testing, but perhaps we'll get there. Other testing methods, such as rapid result testing with urine, oral fluid, or this new hair testing processor, I would say, again, look at the state laws that apply to you. Look for either a federal a Food and Drug Administration, FDA clearance on a device that you're using, or an E&I, employment and insurance use designation. You're on safer ground when you do that. It's also important to note that there's only one drug testing method that's capable, or I should say one drug testing method approved by the federal government, lab-based oral fluid testing, that's capable of detecting drug use right after somebody uses the drug. Remember, I said that with urine, you're looking at 6, 7, 8 hours before the metabolite becomes detectable in a urine sample. But with oral fluid testing, the parent drug, parent THC, becomes detectable in an oral fluid sample within, say, 10 to 15 minutes after usage, right? So if you go back a few years, this is maybe 3 years ago, there was a report that came out from the University of Sydney that identified the window of impairment for marijuana at 3 to 10 hours. It varies, okay? You'll hear somebody talk about this so-called peak window of impairment. That's not realistic. There is no such thing as a peak window of impairment, because the Sydney report and other reports as well, one from the Automobile Club, or AAA, and others have come out and shown that marijuana-induced impairment is just as dangerous at the 10th hour as it can be during the first hour. So you want a drug testing method that detects drug use right away, but also covers that full 10-hour window of impairment, according to the Sydney report. If your objective is to reduce accidents and protect your customers and other workers from safety-sensitive workers possibly being under the influence. To me, they all work, drug testing methods. If you're using a proper method, you're looking at oral fluid, lab-based or rapid, urine, lab-based or rapid, and hair, lab-based or now rapid with the Wanful product. And my point in mentioning all of that is just make sure that you're using it in compliance with the laws that apply to you, and that you're using a testing method that meets your needs, that's going to help you accomplish your objectives. You may not want or need a recent use detection method, but you might. And if you do, then oral fluid testing is the way to go. Excuse me, you may want one with a broader window, a longer window of detection, because you're looking at, as a pre-employment screen, lifestyle drug use detection. Then maybe you're looking at hair testing with its 90-day window of detection, etc. Just know what your objectives are so you can put in place a drug testing method that will help you achieve those objectives. Excuse me. So use a drug test method that can detect all other common drugs as well. Just testing for marijuana is probably not a good business decision. The abuse of other illicit drugs has increased right along with the increase in marijuana use over the last 5 years, especially since COVID, amphetamines in particular. Confirm all non-negatives at a laboratory. Use a medical review officer to make sure that you're verifying that laboratory result. And when possible, utilize the SAMHSA guidelines for your MRO service, for your collections, etc. Depends, right? Now, I mentioned earlier that we now have SAMHSA and DOT guidelines for lab-based oral fluid testing. But some of the components of those regulations, which only apply to lab-based oral fluid testing, could be applied to a company program that's using rapid oral fluid testing, like confirming positive or non-negative results, presumptive positives, or using an MRO to verify results, etc. There are many ways to use those guidelines in a rapid oral fluid testing program to make sure that you're building a solid, legally defensible drug testing program. Now, don't discriminate, right? We're going to comply with all the marijuana laws to a T. We're not going to discriminate. You can do this without treating marijuana users somehow differently than all your other employees. Now look at that third bullet. The only thing you're required of marijuana users, excuse me, is to do their duty, do their work, show up on time, show up fit for duty, and do the job that you hired them to do, just like everybody else on your staff. Again, just because marijuana is legal in most states, it doesn't mean that employers should surrender the right to deal with marijuana in the workplace through your policy and with a drug testing program. It bears repeating, you have the right to prohibit employees from bringing marijuana to work, using marijuana on the job, and being at work while under the influence of marijuana. And if you're a drug testing provider on this webinar today, if you're a drug testing provider, educate your clients on this subject so they can make good, solid business decisions and rely on you as a source of accurate, up-to-date information on these very, very important topics. Ask them the right questions so you understand what their objectives are, and then you can guide them toward achieving those objectives with the right kind of program in place. And this is a little bit of a repeat of everything that I've said already up to this point, but as a conclusion, I think it's a good thing to test for marijuana. Just do it in compliance with the laws that apply to you. Make a good faith effort so that nobody can ever come back to you as an employer and say, you didn't even try, and you hired this guy, and look at the damage or the harm that he's caused because he was under the influence of marijuana because you don't test for marijuana or you don't screen applicants for marijuana. As I said earlier, you can test for marijuana in every state, even New York, under very limited circumstances in New York, but even in California and Washington, as long as you test in compliance with the law, you're using the right testing method allowed in those states. Otherwise, there are limitations that apply in states like Nevada, for example, but you can test for marijuana in every state, although there are some states like Nevada, like Colorado, like New York, New Jersey, where there are restrictions in place and you've got to know what they are. So the takeaway from this is comply with the laws that apply to you to make sure that your program is legally defensible, and then enjoy the benefits of it by having a legally defensible program in place that puts you in the strongest possible position to maintain a safe, productive, and healthy workplace. And that brings us to the conclusion of our prepared part, but now we can entertain questions, Greta.
Thank you, Bill. And please, to our audience, if you have any questions, pop them into the question section and we will be more than happy to answer them. Bill, for our first question, if the federal government legalizes marijuana, will it affect drug testing?
Well, that's a really broad question. Okay, how could the federal government legalize marijuana? Well, perhaps, as I mentioned earlier, by reclassifying marijuana as a Schedule III drug as opposed to a Schedule I drug. Right now, Schedule I, it's in the Schedule I category with heroin and cocaine. There are no known medical uses for Schedule I drugs. They are subject to abuse and addiction. Schedule III drugs have looser restrictions that apply to them. They can be prescribed by doctors as opposed to Schedule I drugs, right? So if it was put into Schedule III, it would loosen up a lot of the restrictions that have historically applied to marijuana. It wouldn't make it legal federally, but it would sort of eliminate many of those restrictions that have applied in the past. What would the effect be on drug testing? I believe that if that happened, there would be a safety sensitive carve out in the law that would allow, like the Department of Transportation, to continue requiring employers to test for marijuana under the DOT regulations, regardless of what state you're in. Those DOT regulations preempt any state laws. In California, for example, where you have that restriction on testing for marijuana with urine, it doesn't apply to DOT covered workers. So DOT covered companies must still test for marijuana, and as of right now, use lab-based urine testing to conduct those tests. I don't think that the legalization of marijuana would eliminate drug testing legally. And what would it do to all of these state marijuana laws, right? Like the ones I mentioned, in Colorado, New Jersey, New York, et cetera. There would be quite a sort of a conflict between these state laws and federal regulations that would probably be very loose when it comes to any kind of assumption that the federal government's legalized marijuana. I don't think that that would happen. And I don't think it would eliminate drug testing.
Thank you, Bill. We have another question, very interesting. The attendee is asking, any recommendations for educating client companies as well as internal HR without imposing on policies? We are a collection site, but also internally test our own employees for pre-employment, post-accident, and suspicion.
Well, I'm going to answer that question in two ways. One is, of course, there's lots of information always coming out on the marijuana issue, its legalization, what states are doing, what companies are doing, etc. I wouldn't necessarily follow the example of some big companies that have publicly made a big deal of the fact that they're eliminating marijuana from their drug test programs, because in many cases, they're still doing some testing for marijuana, even though they may not highlight that. What I would say is put a program in place that respects the rights and the privacy of your employees. I'm talking for your internal program right now, and maybe advise your clients to do the same thing without acquiescing on the actual restrictions of that you're entitled to do in every state. There are no restrictions on what I'm about to say. You heard me say it a dozen times in this webinar. You can still prohibit your workers from coming to work under the influence of marijuana, from having bringing marijuana into the workplace, or being impaired by marijuana, or using marijuana while on the job. So I would definitely update your policy to reflect those things, and then tie it to what the possible consequences might be for individuals who violate the policy. And I would pass that same information on to your clients. Now, the second part of my answer is that if you're concerned about infringing on the rights of your workers who maybe live in a state where marijuana use is legal, and you don't want to get caught up in any legal challenges, etc., then use a drug testing method like oral fluid with its much shorter window of detection, about 12 to 24 hours for marijuana. And I've heard longer windows of detection, but that's the one I go by, that wide range of 12 to 24 hours for marijuana. And with the ability to detect very recent use within minutes after somebody smokes a joint, that marijuana is going to be detectable typically in their oral fluid sample. And that way you're not detecting drug use that occurred over the weekend, but you're detecting fairly recent, even very recent drug use with oral fluid testing. And that may be a happy medium for a company that's concerned about infringing on the rights of their workers in legal marijuana states.
Thanks, Bill. We have another question. It's actually a two-part question. If you are a company in multiple states, do you follow the state laws based on where the person lives? And also, how often should an employer revisit their drug testing policies?
Well, the second part of your question is easy to answer. At least annually, update your drug testing policy, keeping in mind that there are laws that change during the year and go into effect during the year. And if they apply to you, like this new Minnesota law, let's say you want to do rapid oral fluid testing and you're in Minnesota, when that law passes and goes into effect, which happened this last summer, you're updating your policy to reflect that change so that as you start doing rapid oral fluid testing of your employees and applicants in Minnesota, your policy reflects that. So often, but at least annually. Now, as I said earlier, which law applies to your drug testing program if you're in multiple states? And I blanket said all of them, right? But your question sounds like it's a little bit different, which is what law applies to the employee who lives in a different state? And the answer to that question is typically the state law where they live applies to them. So let's say you have workers in Oklahoma, just on the other side of the border from Texas. Those Oklahoma employees are going to be subject to the Oklahoma law because they live and work in Oklahoma, and your employees in Texas would be subject to Texas law, which is not actually so much a law in Texas. But the point is that the law where they live typically applies to them. Not while they're traveling on business or something like that, but I'm talking about where they live and where they work. But I would advise you to update your policy to reflect those possible scenarios and make sure that your legal counsel has weighed in on it so that you've understood the drug testing laws that apply to you. Now, of course, not all attorneys specialize in drug testing laws, so if you need help with that, let us know. But make sure that they've looked at it or somebody's looked at it to make sure you've interpreted the law correctly.
Thanks, Bill, once again. And we have someone wondering if you think more states will pass restrictive laws like California and Washington.
Well, so those two laws are restrictive in the sense that, they're trying to, maybe they were misguided a little bit, but they were trying to protect the rights of their residents when it comes to using marijuana, because marijuana is legal in both of those states, right? Whoever wrote those laws didn't really understand drug testing very well, because what they probably meant to do was to prohibit drug testing for marijuana, but they left the door wide open for oral fluid testing, for example. I predicted back in 2023, waiting for these two laws to actually go into effect in January 2024, that more states would more states would pass these laws like California and Washington. I think that may still happen, but it wasn't, we didn't see any new laws like that in 2024. I thought we would, and we didn't. So I'm a little bit less bullish about it going into 2025. As I said, there were almost 600 bills introduced at the state level that, if ever passed or enacted, would have either a direct or indirect impact on workplace drug testing. Many of those were marijuana laws, not necessarily new marijuana laws, but updating or amending existing marijuana laws. One of the things that we've seen over the last 10, 12 years is that a state will legalize marijuana whatever way they can get it legalized. And then within a year or two or three, they're starting to put more bills out there to add more components to the legal marijuana to make it more marijuana friendly. And so you see that over the course of time. California and Washington were both states that had already legalized recreational marijuana use. And then suddenly in 2022 for California, I believe it was 2023 for Washington, we got these two new laws that would have a direct impact on workplace drug testing. I think we'll see more of that, although it may not be exactly the same as what we have now in California and Washington. And again, I'm not sure that's what the end result that they were hoping for in California and Washington, but that's what they got. They left the door wide open for oral fluid testing. So we're seeing a lot of companies in California, especially somewhat in Washington, that have asked for help in updating their drug testing policy to reflect oral fluid testing because they want to continue testing for marijuana.
Thank you. And for our last question, which drug testing method is most accurate at detecting marijuana?
Well, go back to one of the things I said on one of the other slides, which is use a drug testing method that has been approved by the federal government. That's one thing you can do, right? Use an FDA cleared device or an E&I designated device for rapid testing, or use a SAMHSA certified laboratory, etc. Those are some of the things that you can do to make sure that your program is as legally defensible as possible, but also it bakes into your program the accuracy of the results that you're getting from either that rapid result or from the laboratory. Very generally speaking, urine testing, hair testing, and oral fluid testing are all accurate. They're all accurate at detecting marijuana, but there are different things to take into account, such as cutoff levels. The cutoff levels for marijuana typically for rapid testing are different than lab-based testing. That's not necessarily a bad thing. They're just different, and it depends on what you're looking for. So you want to know those kinds of things, but the actual being able to detect it, if you're using a reputable device from a reputable company, then you're probably on pretty safe ground, but you want to make sure that your policy reflects how you're doing drug testing, rapid versus lab-based, oral fluid versus urine, etc., so that if any challenges ever arise, you can come back to your policy and say, this is how we do it, this is how we do it every time, and that continuity from test to test to test will be one of your greatest defenses if you're ever challenged with your drug testing program.
Wonderful. Thank you, Bill. We're coming to the top of the hour, so let's wrap things up for today's presentation. On behalf of the Current Consulting Group and DrugPak, we hope you found today's presentation informative and helpful. I want to thank Bill Curran of the Current Consulting Group for speaking on this topic and sharing his expertise. If you submitted a question that we didn't answer here today, we will answer you offline, and we will also send you information in a follow-up email on how to access the recorded version of today's presentation. And in addition, we will also send you continuing education information for those of you that qualify to receive 1 credit for attending today's presentation in its entirety. Thank you for your attendance today, and this concludes today's webinar. Have a wonderful day, everyone.